Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Maryann Petri, and today I have a return guest on. I have Michael Sayen. The last time he was on was January 19th, Season 3, Episode number 9. And what we're going to talk about today is what reversing Roe versus Wade could mean to parental rights. So we have a lot to talk about, and I welcome you back to the show. Michael, how are you?
Hey, Maryann. Thank you. Doing well.
Oh, good. So, this is a big deal.
Well, yeah, and because what people don't realize is that abortion, gay marriage, all that really stems as far as, the private life of citizens, family, and, what the government can interfere with.
Well, it wasn't written into the Constitution, so that's why the justices, reversed it.
Right. So the question is that the overturning of Roe versus Wade, it's a big hit for women's rights, against women's rights, against feminists, against the women's suffrage movement. But it also is going to play a large effect on what's called substantive due process rights. And that's going to be not only the private rights or the private life of the citizens, but also what is the government's role when it comes to matrimonial matters. In the early 1800s, into the creation of the courts of England, all matrimonial matters were handled by the Church of England, because they deemed that the principle of marriage, divorce, custody, all that stuff was best suited by the church. And it was pretty much considered for all of history a religious matter, because it had to do with the senses of moral, family, and the marriage contract or covenant itself. A covenant is a religious principle. It's not a legal principle. So what happened was, just recently, in the past 150 years, the government has decided to interfere with the family, and thus turning marriage from a covenant into a contract, and then also trying to legalize what happened was Parliament in 1857 took the authority away from the Church of England, gave it to their civil courts, and matrimonial matters were no longer considered a religious sacrament, but it was considered a right, or a private right, or a legal right of its citizens. And it really pretty much took the authority away from the church and gave it to the government and all matrimonial matters. And right now, Roe versus Wade is the beginning of a reversal of the government making decisions based on morality.
Mm-hmm. Mm-hmm. Well, what are these states going to do? You know what I mean? It's just a big mess.
Yeah, well, very first what's going to happen is it's like kids in a candy store, right? As soon as you allow a kid into a candy store, right, it doesn't matter if that kid's hungry or not hungry, if they just ate an entire cake and ice cream from a birthday party. They're going to go in there and they're going to fill their bellies, right, with as much candy as they can, and they're going to go crazy because they're going to take advantage of that right. So what we're going to see is states, more than likely we're actually seeing that, is they're going to go overboard, and they're going to say, hey, this is our right to reverse a decision that was for 50 years in the making, and they're just going to reverse it. A lot of times just reversing it on principle alone. Some are just going to be reversing it just through sheer excitement of wanting to jumping on the bandwagon.
Well, I think, I personally, I'm not for abortion, although I can think of 14 people that should have been aborted. But there's so many contraceptives out there that abortion should be archaic in this day and age.
Right. Well, and so it has a lot to do
Oh, I'm
with
breaking up. You're,
the government's always wanted to control the pop. Oh, weird. Oh, weird. Okay. Just let me know if I break up again. I'm still in my house, so I shouldn't break up. But
okay,
uh, um, so the government has always wanted to interfere. Am I still breaking up?
you're fine.
Okay. So the government has always wanted to interfere with population control, right?
Hmm.
And the Marxism in Russia in 1917, they realized that the private home was an institution that if they couldn't have control in the private home, they couldn't have ultimate control or supremacy of the people. So under Marxism, what they decided to do is they decided to allow unilateral no-fault divorce. And allowing unilateral no-fault divorce, what it did is it broke up the home. And when the home was broken up, they were able to double productivity, bringing women into the workforce, and
Hmm.
thus be a competing nation because now they were able to double their workload. And not only that, but they were able to when the woman was working full time and the man was working full time, what happened to the kids? Well, the kids went to public education, and so the government realized that it was able to control and manipulate and to teach the children. Now we see that also with Hitler. Hitler realized that the most important thing is to control the education of the young. And Hitler always had a large grip on educating and controlling the education of young children. That is not possible with intact families and intact homes.
Hmm.
The population control is an aspect of a lot of elitists today are worried that, hey, is there too many people in this world, right? Is there not enough resources, food, gas? And so one of the things is that we see the modern day house, right? We see the maybe a couple hundred years ago, having 5, 6, 7 children may not have been strange, but in today's atmosphere, having 6, 7 kids, you're kind of looked at as having like a Brady Bunch.
Hmm.
And the government really would prefer that you only have 1 or 2 kids. Matter of fact, in China, for a number of years, people were only allowed to have 1 child, and you either had to abort the second child or give the other second child up
Hmm.
for adoption. And this is the 1-child laws or rules. So right now we're seeing a real pressure by the government to, hey, number one, how can we control the family? Well, we can't control an intact family because they're a government within themselves. They weren't able to penetrate that because of privacy rights. But once that home breaks up and there's a divorce or you have a child out of wedlock, privacy rights really no longer exist. Because what you're dealing with 2 competing biological parents. And when you're dealing with the competing biological parents, the government says, well, we have to come in and we have to be that deciding factor. And as soon as the government gets a hand in there, they're able to do 2 things. Number one, they're able to they do several things. Number one, they're able to control the population. They're able to push women to enter into the workforce, thus doubling productivity of that nation. 3, they're able to get the children into public education, so they're able to control what the children are going to learn and how educated they are. Right.
Hmm.
A lot of times, the government doesn't like private education or homeschooling, because not only do they not get to teach or push their agenda, just like we see the LGBTQ rights being pushed in the public education. Well, in a private sector or in a homeschool, the government is not able to re-educate the children, right? As
Hmm.
far as what is the accepted moralities. So you have, but there's just a whole slew of, and then also, as we know, that divorce itself was a $50 billion industry, and it's the divorce courts and family courts and juvenile courts, married or not married. You're right. People don't understand. You still go through family court even if you were never a family. A woman has a child outside of wedlock, right? Well,
Mhm.
now for the first time in history, the man, even if the man raped a woman, the man can say that he would like to have shared custody of that
Mhm.
child. And this is a recent decision by the United States Supreme Court saying that unwed fathers are fit parents, and that they have a right to fight for custody of that child. And so now you have women who have never been married but were pregnant and have a child. Now they're forced into a family court, even though they've never been a family. Like, there's never been a family. There's never been a divorce, never been a legal separation. And now they're forced into a court that where instead of a civil court like divorce was originally handled in America and England, now they're forced into a family court, where you're dealing with the constitutional rights of both the mother, the father, and the child.
That's twisted. You know, um, if a woman is raped by someone, that person should have no rights to that kid.
That's correct. Yeah, and that person should be in jail. Instead of
Right.
punishing, right? Instead of punishing the offender, they're actually awarding the offender, and they're saying, well, a recent decision, I think it was either Texas or Washington, where the question of I don't know if you know the story, is that biological mother, biological father, they had several kids, 3 kids. They were never married. They were together for like 9 years. They lived together for 9 years. And what happened was the mother died. And so what happened was immediately the CPS came in and took the 3 kids. And the father says, well, wait a minute, why are you taking the kids? Well, according to the state law said that, hey, unwed fathers are unfit parents. And so according to the law, those children were immediately taken out of the home, even though they acted as if they were married for 9 years, and the 3 kids were his, and there was nothing wrong with the household. It was just a matter of state statute. Well, that went up to the United States Supreme Court, and basically saying that, well, hey, you're not considered, a man is not considered unfit just because they were not wed. Now, this really wouldn't be a problem, but what happened was when unilateral no-fault divorce came, unilateral no-fault divorce had a major effect on people. Cohabitation increased 900%
Mm.
around from no-fault divorce until today. So it increased 900%. And that is most likely dealing with the no-fault divorce culture coming in, and there's really being no value for marriage.
Mhm.
Because when you have no-fault divorce, there's no legal enforceability of that marriage. Therefore, according to Russia's argument in 1917, no legal enforceability to marriage actually makes no difference between marriage and cohabitation. So really, there's no real value in getting married. Matter of fact, the men are at a disadvantage if they get married,
Mhm.
legally speaking. And so a lot of people are choosing to, choosing not to get married. And because of that, we have, I know in the Black community, as well as now it's trickling over to the white community, but the children born out of wedlock is almost 50%.
Mhm.
There's actually 40% in the Black household, which is a real problem. But it's around 40-50%, both the Black and the white communities, is that people having children out of wedlock, right? Well, according to the Bible, if you have a child in wedlock, now this is according to coverture laws as well at common law for the past 1,000 years of English history, as well as all of American history, that at common law, that a woman, as soon as she becomes married, she takes on her husband's last name. When she takes on her last name, she loses legal identity of herself, and she becomes known as the illegal extension or the legal identity of her husband. That's why the woman took on the last name. It was to legally change that of her husband. Now, when she did that, according to England and the United States, the woman fell under the property laws of the man. She was not able to initiate a divorce because she was considered property. And not only that, but she was considered in America up until 1850s into the early 1900s, she was considered property of her husband, therefore not having the full constitutional rights as a citizen. because she's considered property. Now, you might hear that argument, you might remember that argument, because that was the argument that people made for blacks and slaves. They said, well, the reason why blacks are not protected by the Constitution and the Declaration of Independence, because they said that blacks are not people, they're property. Well, under the same understanding, women, children, and slaves were all considered property of the father, or the husband, or the master of the home. So not until the 14th Amendment came, and the women's suffrage movement using the 14th Amendment to getting the right to vote, to get contracts, to buy and sell land for property rights, were they able to initiate divorces for the first time. And they were able to really get rid of the coverture laws at common law in our court system. And they were able to say, hey, we are people too. Those children are as much our children as the father. And we want equal rights to custody. But what happens is the courts, instead of going equal custody, what they did is they actually went more towards the woman, because they realized that if a couple can't stay married because of arguments, they're not going to be able to raise children because of these fights and arguments. And they thought that, well, because of it would be dangerous to put children in a divorced situation, because they were afraid that the men would become violent, or there would be suicides or homicides, which does increase during divorce time. And what they decided, that it was best to give the child to either to the mother or the father. And since the father was considered the breadwinner in the early 1900s, and the woman was considered the nurturer and caregiver, which she's been mostly doing at the home after a marriage, that the courts just started giving, through what was called the tender years doctrine, they just started giving the children, 100% of the children pretty much, to the mother. So what happened was in 1850 or around 1875, it went from all the children be given to the father after a divorce based on coverture laws, to all the children being given to all the mothers under the age of 4, 7, or 9 years old, depending on the court, because of the tender years doctrine, saying that men can't breastfeed children. So long story short, we had a really, in the late 1800s, early 1900s, a real unstable environment with the family. And with the unstable environment, the government came in. When the government came in, they were able to realize that when we have a foothold in the home, we're able to, as I mentioned earlier, we're able to get women into the workforce, we're able to double productivity, we're able to teach and train the next generation of children. And not only that, but they're able to make tons and tons of cash, because the divorce industry and child custody, the government realized that the men and women will spend millions and billions of dollars here in America to fight for their children. And the government is the one who wins. The government wins. So the government has no reason to try to stop divorces. They have no reason to try to stop cohabitation. They have no reason to try to stop any of the perversion of the family, because the more that the family's destroyed, the stronger and the richer that government becomes. And Marxism realized this in the early 1900s.
Yeah, that's a lot of history. It just, there's just so much anger over this reversal, you- who can predict where all this will lead, with all the states making whatever decisions and when?
Right. And so what we see, and how this decision is going to directly affect family law, is that what we have what's called a compelling state interest. The government can't go into a home and can't tell you what to do with your children and raise your children, what religion you can raise your child, freedom of speech, all the other rights, right? How to raise your child, how to train your child. They can't do that unless the state has a compelling state interest. But what happens is the reversing of Roe versus Wade is it's going to destroy that compelling state interest. Now, the reason why is because Roe versus Wade did two things. It reversed precedents, so stare decisis, and that says, hey, let the decision stand in Latin. What it did is reverse that and said that, hey, 50 years of precedence is not precedence. If the decision was foundationally wrong, then there is no precedence. Now, that's a really big deal because, the abortion's been going on for 50 years. And the court turned around and said, well, hey, there is no precedence because the decision, Roe versus Wade, was wrong for 50 years. Therefore, the court looks at it as a no big thing to overturn Roe versus Wade. And that's why people are all upset, because you can't tell somebody for 50, you can't tell a generation, you can't tell a country, you can't tell a nation that they had a right for 50 years, that this is a constitutional, fundamental, natural right to have an abortion for 50 years, and then turn around and say, oops, because the Supreme Court is the one who actually made the decision Roe versus Wade. It wasn't like they were reversing a federal law, right? They weren't reversing a federal statute or a state statute, right? They weren't getting involved in reversing somebody else's decision. They're reversing their own decision, right? It would be like this. It would be like your mother or your father telling you as a kid, hey, you need to go to bed at 9 p.m. every night. And then you're going from 9 p.m. and all of a sudden you become 13 and you're thinking that you're going to have an expansion of rights, right? You're going to be able to stay up later. The parents come and they says, well, you're not able, on school nights, you have to go to bed at 8 instead of 9. The child's going to be like, what kind of logic is that? And then the parents say, well, you know what? We made a mistake. We should have never allowed you to stay up to 9. So we're going to go ahead and we're going to reverse our decision, right? Even though there's a long precedence. And you're going to have to go to bed at 8 now, right? Well, you better
Mm-hmm.
believe that the child says, well, that's not reasonable. That's not logical. And that's the problem that a lot of liberals and even conservatives and Republicans have with the reversing of Roe versus Wade is that, hey, you've been telling us that this is a constitutionally fundamentally protected right. It's an enumerated right, because that's how something becomes fundamental. You're saying this is a enumerated right based on the 14th Amendment due process, the substantive part of the due process, not the procedural part. And now you're just saying, oh yeah, oops, we made a mistake, and you're taking that right away from us. So the concern is, what other rights will the federal government take from us? Especially what other rights have we been practicing? What about the Second Amendment? That's a right. Will the government say, well, hey, you're not allowed to have, or what about freedom of religion or freedom of speech? What other rights will the government say, well, we've been doing this for 50 years and you've had this right for 50 years, but we're taking this right away from you. And that's what the problem that most of the liberalists, the left wing, they have now. And they're saying that, wait a minute, we're going to see the government increase its power, right? Not only in the home, but in all areas of life, and actually limit what they believe is a fundamental right. And they are correct. The United States Supreme Court has said, since Roe versus Wade, and Justice Scalia was very vocal about this, Justice Scalia said, substantive due process needs to go away. It doesn't really exist. The only kind of due process rights you are guaranteed are procedural. Substantive means it's like this. The 14th Amendment guarantees the due process rights of that you can't have your life, liberty, or property taken away from you, except for unless you have a court hearing, unless you have due process. Well, that says nothing about privacy rights. Matter of fact, if you look, no state constitution or the federal constitution says anything about privacy. Nowhere in the Constitution does it say that the government can't spy on us, right? Can't listen to us. It says it has privacy. But privacy is actually something that was made up through the 14th Amendment, because what the justices said was, well, hey, the due process clause means more than just procedural. It means something more. Now, we really can't figure out what it means, but one of the things we think it means, based upon other wording in the Constitution, is that we believe that privacy should be protected, right? Limited government interference. Well, limited government interference is nowhere in the Constitution, like specifically. It's not enumerated. It doesn't say. So what happened was, long story short, the Roe versus Wade, the courts, for the first time, they were able to say, well, hey, privacy rights really don't exist. Substantive due process rights really don't exist. We're going to start taking control and more limiting what you can fight into federal courts for. So one thing we're going to see in the family courts is that ability to say, hey, the state government, right, or the lower courts or family courts, they're violating, they're giving me a court order saying I can't raise my child as a Christian, but I have to raise my child as a Muslim because my spouse who divorced me had converted to Muslim. Right. And now since the child and since the parent that divorced me is a Muslim and they got custody, primary care, therefore they get to have control of the child. And I no longer can teach my child about Jesus or my religious ways. Now we are actually seeing this. We are actually seeing this in James Younger, where what happened was the non-biological mother gets custody of the 6-year-old child, which is probably younger than 6 years at the time, but James Younger. And then what the stepmother or acting mother or guardian, after she got custody, she just decided to say, hey, I want my child James to be called Luna, and I want her to raise it as a girl. And so the court said to sorry, but maybe it's James's might be the father's name. But the court said to the father, well, you're the non-custodial parent. The mother has control. It doesn't matter what your religion says, but you need to raise your boy as a girl because the main custodial parent that the court gave the rights to said that your child is a girl. So if you don't say that, if you don't call her by the new name, you don't call her him or her, then you'll never have visitation of that child again. At least you confuse the child on their sexual identity. So we're starting to see with the Roe versus Wade being overturned, saying there's no substantive rights in the 14th Amendment that's guaranteed to people. We're going to see that the family court judge is really able to no holds barred once the child enters into that courtroom, once a family enters into that courtroom, to be able to say what the judge can and cannot do or cannot order. So there's a big fear of that. So we're going to see a negative, more than likely say a negative play on the reversing of Roe versus Wade, because what it's going to say is that the federal government is not going to be able to reverse lower court states' decisions based on fundamental or constitutional rights. Now, on a side note, the federal government has never reversed, they're not appellate courts, and they never reverse lower courts' decisions or state courts' decisions based on divorce, relations exemptions, Rooker-Feldman doctrines, and other doctrines. They've never really got involved and overturned or protected people's individual rights. But now, for the first time, the lower court judges really have more say in what they can order your kid to do, or for you to do to your kid, or not to do. Now, but there is a good note on the reversing of Roe versus Wade, is that the Roe versus Wade says that the court has admitted doing something for 50 years is a precedent if, or stare decisis, if that original decision was wrong. Now, Roe versus Wade was actually had a second case that so Roe versus Wade was about, hey, when does the right to life, right? When does that child has a constitutional right? And Roe versus Wade says, well, hey, if the child can't live outside the womb, or actually back this up. Planned Parenthood versus Casey said if the child can't live outside the womb, that the child really has no rights, and the state can't put an undue burden on the mother to raise a child to term if that mother doesn't want to raise that child, and thus confirming Roe versus Wade. Roe versus Wade, actually what the court said was, hey, maybe late-term abortions should be unlawful, because as the child progresses in months, right, that as the child progresses in age, as in the ability to sustain itself outside the womb, so should the rights of that fetus increase. Does that make sense? So so Roe versus Wade, the justices said that, hey, if you're just pregnant for 1 month, right? Well, that, it's just floppy tissue. Who really knows scientifically where that child is developed? But that child or that fetus has less rights than if you take it to term 9 months and it's ready to come out the womb, and then you give an abortion the day before you're like, well, obviously there's a major difference on, can that child feel pain? Is it able to express thought? Is it able to breathe? Is his heart rate different than its mother? So what happened is that they said, well, the justices said, as far as the right to life, the child's constitutional rights, when does that kick in? Well, as the child or the fetus becomes older, in the third trimester, they believe that more rights should exist for that unborn child. Well, Casey versus Planned Parenthood versus Casey, what it did is it actually said, no, if that fetus at any time can't live outside the womb, right? Fetus viability, if it can't live any time outside that womb, then the state can't put an undue burden saying that the mother has to carry that child to term. And because of Planned Parent, or because of Roe versus Wade, of privacy rights, the government can't watch what you do if you have your child or if you don't have your child, right? So long story short, when that reversed, it also it really played a big part in what's called stare decisis. Now, the reason why family court is in the way it is in the states had ultimate supremacy of people, right? In the early, from its conceptions until 1833. And so it really had complete control of its people. In 1833, there was a landmark decision. The Supreme Court said in Barron versus Baltimore that the Bill of Rights don't apply to the states. It only protects the federal government from interfering in the fundamental rights of citizens. Therefore, the states were able to violate the Bill of Rights for many years, 40 years or so. And then what happened was the 14th Amendment came that reversed the 1833 decision and said that, wait a minute, now the Bill of Rights through the incorporation doctrine, the Bill of Rights do apply to the states. So the states do have a responsibility to let you have a Second Amendment right, First Amendment right, the freedom of speech, due process. And so that was to force, the 14th Amendment was to force the Bill of Rights back to the states. Well, what happened was, before the 14th Amendment came, all the supremacy was to the states under the divorce relations exemption. And the federal government said, hey, we won't get involved if the state is violating, right, a fundamental right in your divorce or in your custody, even married or unmarried, right? Have a pregnancy, be pregnant in the marriage or out of the marriage. So they gave all rights to the state. Well, what happened was that domestic relations exemption became what was known through stare decisis, is it became precedent. But when the 14th Amendment came saying that, hey, the Bill of Rights is now incorporated to the states, people said, well, if that's the case, then if I have a divorce, I should have some rights to my child. Now, remember, women were really fighting at the time for this, not men, because up until this point, majority of divorces and custody was pretty much given to the man almost exclusively, unless that child was under the age of 4. And that eventually increased from 4 to 7 to 9. But mostly the mother had to give back the child to the father after the child was weaned from the mother's womb. Or from the mother's breast. So she had to give back that because it was because it was still considered the property rights at common law. So the court slowly changed. The court changes very slowly. And so for women to actually be given the right to vote in 1920, to be able to initiate divorces in the really early 1900s, to be able to get legal custody, that's a long process. Well, as that long process happens, right, precedence kind of sets in. And the federal courts say, hey, under federalism, we don't want to overturn state courts' decisions. We want them to have really ultimate supremacy unless it's enumerated right. And parenting is not an enumerated right. Well, that was recently challenged in Troxel versus Granville. Troxel and Granville said in 2000 that Justice Scalia, or it actually said in there that parental rights are fundamental. So it actually uses the word fundamental. By using the word fundamental, that's a key word. That means it's an enumerated right that's mentioned in the Constitution. So for Troxel and Granville in 2000, for the first time, we actually have this United States Supreme Court admitting that the parental rights are a fundamental, natural, God-given, protected rights, and both the state and the federal government have a responsibility to make sure both the biological mother and the biological father have care, control, and custody of that child, even if they were never married. So that the lines, and the reason why the court said this is the court said, well, they got together and they said, this is a true story. The United States Supreme Court said, well, divorce is now skyrocketing, right? It did since the early, right, from the early 1969, 1970s, and it started skyrocketing. And so what the court said is, you know what, we really can't make custody decisions based on marriage anymore, because according to society, we're living in a society that's dealing with a lot of people are broken marriages, right? So they said, we need to start treating custody regardless if you were married or unmarried. We need to start dealing with this as a biological issue or an inalienable right, because there's a biological claim to that child. So all of a sudden, being married or not married, right, doesn't have any play on the custody and the fitness of both parents or either parents. So that line was blurred by the United States Supreme Court in the early 1800s, or sorry, in 1980, 1990, somewhere around that. So those lines were really blurred. Now, another thing, which is important to say, I'm going to back up a little bit, is that Roe versus Wade, it said the government under privacy rights can't interfere, can't tell us what to do, right? There was always the government tried to say, well, women can't take the pill because the government said, well, that's murder, and so you can't take a pill. But then it's like, okay, well, what line does that government have the right to know about your pregnancy if you are pregnant, and to be able to say if you can have a pill, not have a pill, have an abortion, not have an abortion, how you raise your child, right? Because it's considered a hate crime to raise your children saying that, hey, homosexuals are bad and evil, right? Well, that's considered a hate crime in America because homosexual marriages are lawful. So therefore, when you raise your child in a religious way, Muslim, Jewish, Christian, any of the major religions, they all say that, hey, homosexual marriages, there's a hint of evil. These people will not go to heaven if they practice this lifestyle. And that's considered a hate crime because now you're teaching your child to disobey what the government considers moral and legal, right? And they're saying, well, the government is saying that, so the government's saying we need to have control of your children. And that's why the government is pushing LGBTQ rights in the public education, because they're doing that because they're realizing that the parents, if they're religious at all, they're more likely pushing a hate crime on their child, right, to cause hate and division. And the job of the federal government, what they want to do is they want to create unity at all costs, right? A nation divided will not stand, right? We read this in the Bible, right? A house divided will not stand. So what they do is they try to create unity. And that's through the expansion of federal government powers, as well as the ability to say, well, wait a minute, we legalize homosexual marriages. Therefore, we need to be able to tell your children what is morally right or what is morally wrong, lest you disobey the government or challenge the government's authority. And homosexual marriage is just such a hotbed right now, where the religious activists and all the three major religions, right, Muslims, Jews, or Christians, are actually saying, well, according to our old texts, homosexual marriage is something that you cannot enter into the kingdom of heaven. We see this in Galatians chapter 5. We see this in 1 Corinthians chapter 6. Right, those who practice such a lifestyle will not enter the kingdom of heaven, and that is considered a hate crime because you're teaching your children that what the government is saying is wrong.
What about, say, like if a pregnant woman is murdered, then that perpetrator is convicted for 2 deaths because of the baby and the mother. So this is going to change that?
Yeah, well, it's interesting. This is actually kind of funny. This is a funny story. So a woman's in the carpool lane. She's driving. The cop pulls her over, right? Obviously, he considers only one person in the in the carpool lane, and they're going down the highway, which according to state statute, this particular state, it says that you must have two people or more in the car. Pulls her over. She says, "Well, I'm pregnant." Right? The police, well, that doesn't count. You need to have a child in a child seat. Right. So the question is that is the child in the womb, does that child have full constitutional rights? Right? Is that child really literally considered a child, or is it just considered an extension of the mother? In that particular situation where the police pulled over the mother, the police said that child needed to be outside the womb to be able to use the carpooling. Right? Because they're saying, that police was saying that, hey, just when a child is inside your womb, you're really just an extension of yourself. And we see this complaint, right? My body, my choice, right? And the big question was in Roe versus Wade 50 years ago, we didn't have the science to be able to say, when is a life become a life? Right. And you hear this in a Catholic complaint, right? They don't allow, Catholics are not allowed to take like birth control or something. It's because the birth control actually will kill the fetus at its beginning stages. So you actually literally, when you're taking birth control, you are killing a fetus. So it's a mini abortion. So scientifically, but it's at the very beginning stage, right? So it's after the stage where the egg and the sperm become together, and then or even the day after pill, or just regular contraceptives, such as the regular pills that the women take, it does abort the fetus, but at such a young age. Now, the Catholics don't allow their families to practice, taking any type of pills, because they're saying, well, a life's a life, and it begins at conception. Now we see that in the Old Testament, where David said, "In the womb you knew me," right? Even before I was born. And so a lot of the pro-lifers were saying, well, God knew David, King David, in his mother's womb, right? He knew him. He called him before that. And so the point of that scripture was saying that, hey, God looks at a life inside the womb as individual of its mother, right? Having its own purpose and plan, having its own destiny. And it clearly in that Psalms passage, that David said, "In the womb you knew me," is that it didn't say before the womb you knew me, it said in the womb you knew me. So it really gives credence to, hey, life is fully sustainable, or is considered not fully sustainable, but a life is considered a life, or begins at the moment of conception. And the Catholics have been preaching that a long time. So the big question, like you were saying, can you repeat your question one more time? Because I think I had a...
Oh, it was that, law that if a woman is murdered and she's
Oh, yeah.
pregnant, then it's 2 deaths.
Yeah.
And the
So what happened?
yeah.
Yeah. So here's an interesting story. Now, this is kind of a gruesome story. So if you have your kids, hide them, but hide them in the bedroom. But so it's a true story. So what happened is in Minnesota, they had a big problem with a lot of the native Indians. And as they came in and they're trying to establish Minnesota as a state. And so there's that real push, right, of the whites come in, and the whites are like saying, this is our right, this is our land. And then the Indians feeling forced out. Well, what happened was the Indians started to rebel. One of the stories was that they gruesome story, but a pregnant woman, they came to a pregnant woman, they cut the womb open, the particular Indian, really savage Indian, and then what they did is they took that child and they nailed the child against a tree, right? So they cut the child, and then after the child died, then the mother died. Right? We see a lot of stuff like this in the laws, where, an example, a man beats up a lady, and she's pregnant. Well, she survives, but the child doesn't. Right? So the question is, did he commit murder? And a lot of people would say yes, and the Bible would pretty much say yes as well. And so just because the child's inside the womb, now, if that's the case, then is there such thing as double homicide with a pregnant woman? Well,
Mhm.
yeah. Well, that's as far as that would look. But again, that's going to have a lot to do with state law. The state law or state statutes are going to really say, when does, how does these laws, right, for protecting and guarding and controlling society, right, protecting the inalienable rights of society and being able that we have unity, right, so we're able to live together in peace, right? Because the compelling state interest is saying, hey, what can we do for the peace of the community? It's not what we could do for control of community, but it's supposed to be able to say, how can we protect the inalienable rights of all the people? Well, recently, since unilateral no-fault divorce, we started to see a push that children are looked at as having constitutional rights for the first time. So this is children
Mhm.
under the age 18. Now, before that, right, under common law, children's constitutional rights were considered part and parcel of the mother and father. So let me back up a little bit. So from Europe or England and the United States until the 14th Amendment, children were considered property of the father. Therefore, the fathers had 100% control of the children. And they were only allowed to stay with the mother during the tender years, but then the mother had to give back the father. So, give back the children to the father after the child was weaned. Now, that was the law, both in England and America under coverture law. So, and then what happened was the 14th Amendment came, and then the women's suffrage movement said that, hey, we deserve 100% constitutional rights under the Equal Protection Clause, and the courts granted that, and now the children were considered both the property of the mother and father. Well, now a recent push has been, because of guardian ad litems and because of Child Protection Services, and Human Services and DC, DFS, and all the other stuff that the government's doing, is they're saying, well, wait a minute, if under the Equal Protection Clause, if the woman has full constitutional rights, shouldn't the child under the age of 18 have full constitutional rights? Should their constitutional rights no longer be considered part and parcel of their parents? And the courts have recently changed, and so you were seeing a change in the air, in the atmosphere, where the actual courts are saying, well, children have a constitutional rights for safe and security, for a safe upbringing. And the government says, however, the children lack the maturity to tell the court what, or even to know what they want. So the government says if there's a disagreement or a divorce or a high conflict custody, we, the government, will decide for the child what is in the child's best interest. And what we'll do is, by deciding what's in the child's best interest, we will actually be protecting the child's constitutional rights that are independent of the mother and father. So we're starting to see this push as the fathers' rights movement goes through, and as now women's rights movements are going through for non-custodial parents. We're starting to see a push where the government's saying, no, instead of 50-50 shared custody, right, where it would still limit the government's ability to be able to interfere, because they would have the mother and father are still sharing that child. The government is saying, no, we don't like that. We're going to go and uphold the child's constitutional rights. And since the child lacks a maturity, what we will do is we will appoint a child lawyer or a guardian ad litem to that child
Mhm.
to be able to say, to be able to fight for that child's rights. And most of the time, if anybody has a guardian ad litem or a child lawyer, they know that the guardian ad litem and child lawyer work for the court. They're normally appointed by the judge, who's actually judges had a long relationship with them. And or if not, they still believe that they work for the court or for the government. And so instead of having, as a matter of fact, lawyers in general, they're first, they have a responsibility first to the court, then to the client. That's actually something that's part of becoming a lawyer, that they actually have to, I think it's legally they have to agree to, right? The responsibility first to the court, then to the client. And we're starting to see this in the guardian ad litem, that now in the UN, under the Conventions of the Rights of the Child, since around the 1990s, they've been using the best interest of the child standards from a long time ago, saying that the government is exercising the rights of the child, right? Because we don't really hear that too much. What's a child's rights? Well, the child's rights is based on, whenever you hear rights, you hear a constitutional right. When you don't hear a constitutional right, you hear the word privilege, right? You have to ask permission, like a driver's license is a privilege to drive, or a marriage license, you're asking permission from the government to get married. These are considered privileges, not rights, right? So what's happening is that whenever you hear the word rights, right, or civil rights, what they're actually saying that this is an enumerated right, spelled either explicit or non-explicitly. We have the word substantive. Non-explicitly, it's not directly spelled out, but it is inferred. And that's the whole thing with the privacy rights of Roe versus Wade, is the government says no longer will we listen to substantive right arguments, that if it's not explicitly mentioned in the Constitution, people really don't have that right.
Well, thank you so much for explaining all of this. It's just it's just confusing. It's just going to be a big mess, with all these states. I'm so glad you came on the show again.
Yeah, thanks. And what we're really going to see is that though we're going to see the government limiting our privacy rights and substantive rights, we are going to see a push against bad precedents, right? Push against the stare decisis. And some of these bad doctrines that we see out there in the family law, such as divorce relations exemption, Rooker-Feldman doctrines, and other things, we're saying that, hey, you have no constitutional ability to file for remedy in your particular court case if the judge has violated a constitutional right. That's called deprivation of rights under the color of law. But we're going to start to see that we possibly might have a reversal, and we might possibly have the federal government getting more involved in the family court and protecting more of our rights and more of our enumerated rights as well, such as life, liberty, and property, and the ability to care and have control and custody of our children for non-custodial parents. So it could go either way. We'll probably see a combination of both, right, where we lose some privacy rights. However, the government, hopefully the federal government will come in and start telling the state government that, you need to honor the non-custodial parent. And we might even start seeing some federal laws regarding child care and custody and control, and divorces and separations, and even non-married couples. So we could see, but we are definitely going to see a change in the legal structure and how homosexual marriage is looked at. It will more likely be challenged now that Roe versus Wade has been overturned. Homosexual marriage, Begefield, I can't pronounce it, but that was in Hodges. That was based on Roe versus Wade, the same doctrines or theories. So since Roe versus Wade was overturned, more than likely, there's a good chance that homosexual marriages will be overturned. But then that plays into the whole thing of what is the government's role and its authority in the family. And we're going to see that. We're going to see a real change. And we'll probably see the United States Supreme Court take on more family cases as well. So it's good and bad.
Yes. Definitely. Oh, if anyone wants to reach you with any questions, how do you want to be reached?
Usually you can reach me at mikesayen@hotmail.com. I do have, I am on Facebook, as well as I do have a book out there called Remarriage and Adultery. It has my email in there as well. It's free as a KDP download on Amazon. But usually that's kind of the best way to get in touch with me.
Oh, well, thank you so much for coming on the show and talking about this.
Oh, thank you so much, Maryann, for interviewing me again. I really appreciate that. Thanks
And
for your time.
I'll probably have you back on again. So
Yes.
Hey, don't jump off, okay?
Okay, thank you.
Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again here with Michael Sayen in the future and other guests. Thank you again, Michael.
Thank you.